Living trust and real estate. That's what we are going to talk about today. My name is Adana Yarijanian, licensed realtor in California.
Good morning. My name is Sevan Gorginian. I'm a trust and bankruptcy attorney.
Wonderful. Today I have lots of questions for Sevan, which is going to help my clients. Let's go. What is revocable trust and how can it benefit someone buying or selling property?
Thank you for having me, and welcome to my office. This is a pleasure to answer your questions. One of the benefits of having a trust is to avoid what's called probate court. If you have something in your name, like a house, and if you die, it doesn't automatically go to your spouse or to your kids. And ask yourself, how can title and escrow transfer the property to someone else if the person on title is no longer around? That would require the property to go to probate court. It's very expensive, very time consuming. So instead, the benefit of the trust is to put the property inside a trust. Think about the trust as like a box, and that way you won't have to go to probate court.
Are there any advantages to using a trust when transferring real estate to heirs?
So one of the benefits is to transfer property to your kids or to whoever you want through a trust. The main reason why people do this is to avoid what's called capital gains tax. So capital gains tax, if your property has appreciated throughout your lifetime and has increased in value, let's say $2 million, and if you sell, you'll pay a big capital gains tax on
Correct.
that amount. But if the property is transferred to your kids through a trust, your kids will not be paying that tax, okay? So I think we pay enough taxes.
Something great to know, right?
We already pay enough tax.
True.
So it's important to transfer through the trust. Don't add your kids on title. A lot of parents think, let me just add my kids to title, so when we die, it goes to the kids. Do not do that.
That's a great thing to know. What legal considerations should buyers keep in mind when purchasing a property through a trust?
So if you're the buyer, you're buying it through the trust, one thing to keep in mind is the person who is selling it to you from the trust, do they have the permission, and are they the right person that is in charge of the trust to transfer the property out of the trust to you? I have seen situations where buyers purchase the property and it turns out that they were actually, the seller was not authorized to transfer the property out of the trust.
So this is for sellers being in trust.
Correct.
Okay.
Yeah, so you got to be sure the person in charge of the trust has the authority to sell the property.
Correct. And what we usually do, if we get a seller like gets in a trust or power of attorney, we usually for sure run it by title company.
Correct.
And try to confirm that it's legit. They are really in a trust. It's not a fake thing, and then we can move forward with a transaction.
Yeah, so it is the job of title to verify that. I have seen some title companies not actually read the trust documents. Because sometimes, let's say I am the trustee of the trust, but if the person requires another person's approval, and if the title company doesn't get that second person's approval, because that's what the trust document said, that's a big problem. So just make sure your title company is reviewing the trust documents itself.
Definitely. That's like one of the important things. We try to use like very legit, very specific escrows or titles. I mean, at least I personally and my deals try to go with the ones that I'm sure they are doing everything in a correct way. So we are not in trouble later on and clients are safe. And of course, the attorney who did the trust also had to be done everything correctly.
Correct.
So. Can you explain the role of a trustee in a real estate transaction involving a trust?
The role of the trustee involved in the transaction of a trust is that person needs to make sure that, number one, they have the permission to sell the trust assets, the house, out of the trust. Number two, that trustee is in charge of signing the documents. Now, that might seem obvious, but if you require two trustees to sign off, because some trusts the parents require two of the kids to be co-trustees together, and if they don't both agree, then one of them can't just go sign it off. So another thing you got to be sure is, do you need more than one trustee to sign off? The other way this also comes up is something called a trust protector. The trust protector is basically a third-party advisor that makes sure that the kids are protected. It could be an attorney, it could be a real estate advisor. So essentially the trustee needs to take it to a real estate professional and say, this is what we're trying to do, do you approve? So you need the trust protector to approve. Basically, it's oversight, it's management. So basically, you need to follow those trust instructions carefully.
Is there any specific thing they can do, let's say if they put two trustees, choosing any percentage for each one, or who has authority to other one to sign off or not?
Yes. You can designate it as any way you want. Yesterday I had a client, there was 3 kids, and my client wanted one of them to sign off the documents, but wanted the kids to agree in the future if they're going to sell the property. I told them, don't make it a unanimous decision, all 3 have to agree, just make it majority. So 2 out of the 3 kids have to agree to sell this property. So that avoids conflict, and yeah, so that's how it's usually resolved.
And what is the difference between will and trust? Most of the time I guess it gets mixed, people get confused.
Yes, and surprisingly there's even some attorneys that are confused. A trust and a will, they work together, okay? The most important one is the trust itself. So the main difference is a will is something that you use to transfer personal property, your jewelry, money, artwork, things like that. So things that don't have title. For example, people always ask me, does everyone need a trust? The answer is no. Only if your assets are more than, let's say, I think the legal limit is about 170,000. So my grandma, okay, my grandma is going to be 99 years old, and she still goes to casinos. She doesn't have anything, okay, but she has some artwork and she has some money. She doesn't need a trust because everything she has doesn't have title. So she could just use the will to say, you know, my daughter gets this, etc. So that's one difference. Now, if things that do have title, like a house, cars, bank accounts, those have title, you need a trust in order to transfer it. And lastly, the other major difference is a will. If someone challenges it, the will need to be submitted to probate court to be approved. So I can say in my will, I could just do a will and say, Adana gets my house. But you will need to then take that will, take it to the probate court. The probate judge needs to approve it to make sure that's my signature, my brain was working in order to prove it. So always use a trust.
How can a trust help protect the interest of a seller in a property transaction?
Number one, again, it'll avoid the probate court involvement. Number two, otherwise that escrow is going to be a 1-year escrow, I promise you.
I had once, we were in it like 4 months and we were glad, okay, we closed it in 4 months.
So that's one way. The other way is, again, you want to be sure that the person selling the trust assets is authorized to make sure it's transferred for the best interest of the kids and the beneficiaries.
Wonderful. And then are there any specific tax benefits or implications when using a trust for real estate transactions? I know you mentioned we will avoid some taxes, but if we can go more into details of this.
Absolutely. So there are many tax savings components to it. One of them is the estate tax, also called the death tax. Honestly, it doesn't apply to a lot of people because the limit right now is somewhere about $11.1 million per person. So if you do have assets that's more than $11.1 million, you'll pay a very, very hefty estate tax upon your death. Well, your kids will, not you. You're already long gone. But so now that number, the 11.1 million, is scheduled to what's called sunset, meaning terminate in a few years. I think it's 2025. So it's going to come down back to 5 million-ish, unless Congress approves it and they keep it at the higher limit. So now, if your assets are worth more than 5 million, your kids will pay a very large estate tax. And it's at that time, as you can see from the real estate values these days, it's going to be very easy to go over that $5 million limit. If you have, let's say, 2 or 3 properties, you're definitely over the limit.
What steps should buyers and sellers take when setting up a trust for property transaction?
In my office, we have streamlined this process to make it very efficient. And sometimes even the clients are very surprised, saying, wow, that's it? The answer is yes. All we need is a very brief 5-minute questionnaire to be completed online. I created the questionnaire, so I know it's going to be easy. We don't give clients a 20-page question and say, come back. It's online, it's very easy. All I need is that completed, and I need your photo ID, and we will find the deed to the properties. Once we get those, your trust documents will be ready in 48 hours for you to come and sign and finalize. So we handle everything. We handle all the trust documents, we get it recorded. Everything is handled in my office.
That's great to know, and I already had lots of people doing the trust with you.
Thank you.
We would definitely recommend. Also, I was gonna say to anyone doing real estate transactions with me before end of the year, either selling, buying, whatever, and planning to do a trust with Sevan, I will cover all your costs. That's my gift to you if do any purchase or sell and getting the trust before end of the year.
That's very nice of you. The most common questions that also come up is, how do I put my corporation or my LLC that owns the real estate into my trust? We also handle that as well. So think about the trust as like a box. If you have a rental property that's owned by an LLC, we don't put that property into your trust. What we put is your LLC shares that own the property into your trust. So your trust will own the LLC shares, or it's technically called membership interest for any lawyers looking at me. So your membership interest will be put inside your trust, and then whoever owns the membership of the LLC will also own the property that's been held.
Okay, another question came up just from this answer. Let's say it's an LLC, there are 2-3 people, 20%, 20%, like the other one, 60% share. Right? Everyone, for example, myself, I own that 60%. 2 other people which are not included in my trust own the 20%. So if I want to put my LLC into my like living trust, which is for my family, who's gonna be there? Like me only, my share, my part of that LLC, or like whole LLC?
That's a great question. I just dealt with this recently. You can only put inside your trust what you own. Okay, if you own 20% of an LLC, you can only put your 20%. So you don't need your other partners to agree, things like that. Now, with that being said, whenever I see a corporation or an LLC involved with other people, I always ask the clients, go and read what the operating agreement says as far as the corporation. Because if your corporation's books say that you cannot transfer your shares to your family or to a trust, well, then you can't do it.
Oh, wow.
Now, so that's where problems arise.
Even if it's a trust.
Correct. Even if it's a trust. So it starts with the corporate books. You can only transfer what you own into your LLC. If you own 20% of an LLC, you could only transfer that 20% to the LLC.
Interesting.
But I always advise my clients, make sure the corporate books and the operating agreement for that LLC with your other partners says that you're allowed to transfer it. Because if we do transfer it and later something happens, your partners say that transfer is invalid, the corporate books say Adana could not have transferred it, well, then it doesn't work.
That's a very interesting point, because lots of people, specifically like investors, they own few properties. Each property is under like mainly different LLC, right? And most of the time they are not aware like what is the details of that LLC.
Right.
And they try to put it on the trust, and then what happens? You're saying.
Right. I mean, and the other thing that the corporate books can say, not only can or can you not transfer, but if the operating agreement says between you and your partners, what happens when one of the owners dies, that will control over your trust.
Oh.
So if your corporate books say, let's say you and I are partners, and if our operating agreement for our LLC says, if Sevan dies, then his 50% goes to the surviving shareholder, Adana. So that will control. My 50% will not go to my kids. So it's important to know, what do the corporate books say? So we always try to advise our clients properly to make sure the corporate books match the trust, so there's no problems in the future.
Does this apply to, let's say, that asset of the LLC, which might be like property, let's say, and the bank account associated with the LLC, or that one is being handled separately?
No, absolutely. It's all part of the LLC itself. So the bank accounts for the business belong to the LLC. The real estate in the LLC belongs to the LLC, the cars. So I've seen many situations. So it's advisable to make sure those books are clear on what happens when one of the shareholders dies.
What might necessitate updating an existing trust?
There are three times, in my opinion, where people need to update their trust. And my office also reviews and updates people's trust when they need it. The most common one is when they did their trust and their kids were minors at the time, and they had named someone else to be in charge of the trust. Now that the kids are older, they're over 21, that's one time where parents come back saying, we want to update it because we want to put our kids in charge because now they're old enough. The other is in a scenario where, and I dealt with this recently, in a scenario where, God forbid, one of the kids is going down the wrong path in life. Their life is not going well due to drugs, bad credit card problems, things like that, or even bad marriages where they feel their spouse is going to steal that kid's asset. Parents will come to me saying, we don't want our, I'm going to call it the problem child, to receive that 50% immediately. So instead, we will update the trust to put the other good kid in charge and allow them to pay their sibling, let's say $5,000 a month as an allowance, but not let them get the full amount so they don't blow it on gambling or credit cards and things like that.
Great. So basically, main life event is kind of considered.
Correct. Yes.
Changing, even they just get new kid.
Yes. So,
or how about, I'm sorry, getting new properties?
Yes, that's a great question. So most of my clients think they need to come to me when they buy a new property or they get a new bank account, they have a new kid, things like that. So the way I set up my trust is for you not to need me in the future. So I don't want people coming back to me to pay me more legal fees to do this. I look out for the best interest of my clients. So the way I set up the trust is for it to be self-sustaining and you don't need me anymore. There are ways that you can add the title to the property into the trust and you don't need me anymore. And I show you how to do it. Same thing with bank accounts. Even if you have a kid in the future, you don't need to come see me unless you really want to identify the kid. Usually the language we put is any future children born into this marriage will also participate as a beneficiary. Now, you can add their names if you want, but that language is already in there. Now, the key phrase is that's born in this marriage, because unfortunately, if you, not you, but if someone has a kid with someone else and that kid comes and says, well, Adana had $1 million and I'm also her child, sorry, you are not part of this marriage.
True.
So you will not participate. So it has to be biological children born into this marriage.
That's a great detail to pay attention. I didn't know about.
Yes.
There is such wording you can put.
Make sure your trusts say that. Want to avoid that.
Great. And the last thing, what's going on with bankruptcies? Did they increase?
That's a great question. So, so as far as the bankruptcies goes, because I also do bankruptcies, I am seeing the bankruptcy cases go up quickly now. And a lot of people are worried that they're going to lose their home in a bankruptcy. So I want to advise you that your house is safe. You get to have one home, okay, which is called your homestead. Rental properties are more difficult to protect, okay? I'm not saying it's impossible. There are other forms of bankruptcies. But if you only have one house, currently the homestead exemption in California is about $626,000 of equity. So you can have a $3 million house, which is probably a one-bedroom condo in Glendale these days. You can have a $3 million house, but if it has $2.4 million loan against it, there's $600,000 of equity. So you could still file bankruptcy with a $3 million house and keep that house. That's fine. So, but
because it's the primary residence, they are living there.
Right, that's their primary residence. So the other thing I'm seeing that's causing bankruptcy cases to go up is affordability. Okay. Things have gotten very expensive, and a lot of people come to me because they can't afford their very expensive homes, their cars, and their lifestyles. So bankruptcies are ticking up, including the SBA loans are causing a lot of bankruptcies to tick up.
My question, like next one, was exactly for the SBA loans. If people have, let's say, SBA loans, but obviously if it's under their social, they got the loan, obviously it will affect their personal, like social, whatever, themselves. But if they got SBA loan, like under EIN, like LLC, corporation, whatever, they do the bankruptcy for the loans that they just got, what effects it might have for their properties or themselves?
So I want to separate out what you said, because number one, if the SBA loan, and I'm talking about the economic injury disaster loan, the EIDL loan, if that loan is over $200,000, to your corporation, you will have a personal guarantee on that. If it's less than 200, you don't have a personal guarantee. Only your corporation is responsible. I also deal with the SBA loans for corporations that are under $200,000. We've helped many clients this year. It's not a bankruptcy, but we help people with that. So typically, the SBA will try to pursue the owner if you have a personal guarantee. And yes, they can get a judgment against you and put it on your house.
Very great point. I do remember by the time the people were getting that EIDL loans, it was mentioning specifically, I read myself, like you will be the personal grantor for this and you will be responsible. But unfortunately, a lot of people forgot or never read about that. And I did have cases, we were in escrow, they were in process of going through bankruptcy of this like SBA, then everything fall apart because it just affected them.
Right.
And you are able to file those things as well, right?
Yes, absolutely. I have discharged many, many SBA loans. I recently had a case this morning. My client had close to $650,000 in SBA loans we're going to get rid of in the bankruptcy. It is definitely possible. A lot of people, who are not lawyers, they don't do bankruptcy. They tell their clients, you can't get rid of SBA, this and that. That is absolutely not true. So take advice from people that know it and not other people.
The person files for a bankruptcy through this SBA. He is a grantor, let's say, and it started affecting his property. But there is someone else on the title as well. How does that work? Like, are they able to take anything or just half share of how does that work?
So that's a good question. So if you are on title to a property with someone else and someone pursues it or you file bankruptcy, what can they take? In California, if it's your spouse, it's 100% yours. So even if I file bankruptcy, all of the house is part of the bankruptcy. But if you and I are 50% owners as joint tenants on a property, only my 50% is part of the bankruptcy. Your 50% of the house is protected. So if you're married, all of it is part of the bankruptcy. If you're not, if you're business partners with people, then only the percentage you own is subject to recovery.
So too interesting. A lot of people think if they do bankruptcy, the spouse is not affected and the house is not. That's a great point to remember. The other question I'm getting from your answers, 50% share, let's say we do have, how does the bank work? They are gonna come say, okay, sell this property, give the 50%, or they will just put a lien whenever time comes, I own the 50% and didn't do anything. When I sell, they take it. How does that work?
Right. So if, let's say I have credit card problems, and if American Express sues me and they put a judgment on the property that you and I own, only my 50% of the sale proceeds will be subject to recovery when escrow is paying out. Now, let's say that the total equity is $200,000, the sale proceeds, and my American Express judgment is $200,000. Well, you're going to say, wait a minute, but what about my equity? At that time, what happens is the partner can sue the other partner to recover. So if you lose your 50%, you can then sue me and say, because of your credit card problems, we lost the property. So I need my 50% back.
But if the person doesn't have anything at the moment,
the biggest tip I always tell people, be careful who you become partners with. Be very careful.
That's so important, I guess, right? Because there is nothing people get partner easily. I always see someone can't afford to buy this property. They say, I can partner up with someone, my friend, whatever. Let's just do it, finish this transaction. Then these are the things that might happen, right?
Absolutely. And one of the difficulties of my job is when someone comes to file a bankruptcy or they're being sued, I have to notify their other partners on the property that one of your partners is in a lot of trouble. The SBA is suing them, so your commercial property on Glen Oaks is subject to the bankruptcy. So, and look, you don't know. When you're partners with people, you don't know what kind of problems they have. Or if they're getting a divorce and the spouse is coming after their share. Part of my job is what I do is deal with these kinds of problems.
Very great information, Sevan. Thank you so much for explaining. Thank you for having me.
You're welcome.
And I have nothing to add at this moment. Do you have anything?
No, thank you for having me. Thank you for
Of course.
coming to my office. If you want to reach me, you can contact me on my website, 818-928-4445. Visit me on my Instagram, BK Trust Lawyer, and I'll answer any questions.
Wonderful. You will see all the information here on the video already. I guess you are seeing it. Contact both of us. As I mentioned before, if you do any real estate transactions with me before end of the year and you are willing to do a property trust with Sevan, I would cover all the costs. Thank you for watching.
Thank you very much.